Good day, sir. I'm Angelica Pagkaliwanggan of 4G1BS Criminology. So, I am here to discuss the Rule 114 to Rule 118. First is, in Rule 114 is a bail. So, bail is the given security given for the release of a person into a custody of law furnished by him or a badsman to guarantee his appearance before any court as required under the conditions herein after specified. So, next, there are 4 forms of bail. So, after that, I'm discuss it later. So, next is, in granting bail, the judge must conduct a hearing first whether bail is a matter of right or discretion. So after a bail, the judge must conduct a hearing in court. So whether is a bail is a matter of right or discretion. So, right to travel. The right to travel is also restricted by the granting of bail. So, the court may prohibit a person released on bail from leaving the country. So, here are the 4 forms of bail. So, first is property bond. So, a property bond is an undertaking constitute as lien on the real property given as security for the amount of bail. So, must be a resident owner of a real estate within the Philippines. Next is, must be equivalent to the whole amount of bail. Next is corporate security. So, any domestic or foreign corporations licensed as a surety may provide jail jointly by the accused and an officer of that corporation. So, example is a member of a company or a business owner. Next is cash bail. So, in cash bail, cash money posted by the defendant with the court upon condition that such money. So, in cash bail, first is a conduct hearing in the court wherein by the defendant and you must have to pay the bill. Next is recognizance. So, recognizance is like violation of ordinance. The offense is light felony, and the offense is punishable by more than 6 months imprisonment and or 2,000 pesos fine. So, there are the 4 forms of bail. So, according to Republic Act 6036, that no bail is required, that offense is violation only or city or municipal ordinance, and penalty not higher more than arresto mayor 2,000 pesos fine. So, no release or transfer of prisoner except when there is court order. So, no release a person or a detainee in a jail except when the court is ordered. No person under detention shall be released except upon order of the court or when he is admitted to bail. So, under Section 13, Article 3 Constitution, excessive bail shall not be allowed. So, bail is cancelled if the accused surrender proof of his death, acquittal of the accused, dismissal of the case. So, next is Rule 115, right of the accused. So, first is to be presumed innocent until the contrary is proven beyond reasonable doubt. So, the accused is innocent if there is no proof of evidence. Next is to be informed of the nature and cause of the accusation against him. So, the right of the accused to inform the accusation against him. So, next is to be present and defined in person and by counsel at every stage of proceedings, from arraignment to promulgation of the judgment. So, must be so the right of the accused must be by the counsel because he or she defend herself by the counsel or the attorney. So, other rights of the accused is the right to bail. So, the accused must have a right to bail. So, next is promulgation of judgment in absentia. So, it means that the judgment is promulgated even if the absence of the accused, or there is of the judgment even without the presence of the accused. So, must the judge must the accused present in the court by must have present in the court because to inform him the accusation against him. So, the right to be informed the nature and the cause of accusation against him. The purpose of this is to avoid surprise on the accused and give him the opportunity to prepare his defense with the counsel. So, right against self-incrimination. So, this is the accused has the right to not testify against himself in a criminal case. So, he cannot require to be witness either for the prosecution or for to accuse or even for himself. So, trial in absentia requisites. So, first is accused has been arraigned and he has been notified of the trial. He failed to appear and his failure to appear is not justifiable. So, in trial in absentia, so the accused must be in arraignment. The accused must be present. Next is effect of being represented by a fake lawyer. So, accused may appeal and use this ground as violation of right to be heard by a counsel. In Rule 116, arraignment. So, in arraignment, the proceeding in a criminal case whose object is to fix the identity of the accused, to inform him of the charge against him, and to give him an opportunity to plead. So, it is made in open court by the judge. So, furnishing the accused with a copy of the complaint or information, and reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. So, no need to amend the information if the accused pleaded to the lesser offense. Plea bargaining is not allowed for violations of Republic Act 9165, the Comprehensive Dangerous Drugs Law of 2002. So, Rule 117, motion to quash is, when he say motion to quash, it is filed by the accused before arraignment seeking the dismissal of the complaint or information based on the ground provided by the law. So, motion to quash, when to file. So, at any time before entering his plea, and the accused may move to quash of the complaint or information. So, form and contents of a motion to quash. The motion to quash shall be in writing, signed by the accused or signed by the counsel. So, next is Rule 118, pre-trial. So, in stipulation of fact, if the accused and complainants agree on a certain facts, these facts are no longer necessary to prove in court. This is allowed in criminal cases to expedite in the trial. So, why is stipulation of facts allowed in criminal cases? To expedite a trial or dispensing with the presentation of evidence that the accused is willing to admit. So, for example, is to prosecution. So, next is in pre-trial agreement. All agreement or admission made entered during the pre-trial conference shall be in writing and signed by the accused and counsel. So, otherwise, they cannot be used against the accused. So, that's also. Thank you.